have no objections, and I know it's within his right.
I'm gonna I'm sorry to interrupt you. I'm just gonna have the court reporter start the proceeding so we can get the rest of this conversation on the record.
Okay, before we start the proceeding, I have to swear.
You have to.
Sir, can you raise your right hand, please? Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, to help you God?
Yes.
Yes.
My name is Andreen Smith from the law firm Baker Hostetler, here on behalf of the defendant, and we're here to take your deposition today. Would you mind please stating your name for the record?
Kalai, or Carl UMUNNA. Let me just spell it?
Yes, please.
Okay, C-A-R-L-I-S-L-E, or Carl, C-A-R-L, UMUNNA. Also my middle name, U-Z-O-M-A.
Okay. Do you want to reiterate your request that you made at the beginning of?
Yeah, basically, I'm requesting that I want to record the deposition for myself, and also on behalf of Republic reporters.
I'm sorry?
I want to also record myself in the deposition for myself and for Republic reporters, which I'm the publisher.
I'm going to ask the plaintiff to go ahead and make his statement now on the record.
Yes, my name is Alfred Mugonya. I'm the plaintiff in this matter. My name is already on record, but I'm willing to spell it all over. It is A-P-H-R-A-I-M for Alpha. Middle is E-M-E-K-A for Emeka. Last is Ugoye, spelled U-G-W-U-L-N-Y-E. Regarding the request of the witness, I have no objections. I do not have any objections myself, but I want to emphasize that his recording will not constitute the official transcript in connection with this case. So, insofar as his recording is not the official transcript, I have no objection. And regarding the earlier question counsel asked, I think it's within his right to do so. I don't see a reason why not, insofar as his recording does not constitute the official record.
Okay. Are you finished with your statement?
Yes.
Okay. I'm now responding on behalf of the defendant. I'm letting you know that we are opposed to any recording of this proceeding. Under the New York Civil Procedure Law rules, depositions are not public, and I'm going to instruct the witness to turn off the recording at this time.
If I may say something, counsel, in response further, are you operating under New York Civil Procedure rules or under the rules of the court that allowed deposition to occur in New York? Because I might have objected to a deposition in New York if I thought that we were operating under a different rule.
We are operating under the rules of the court that issued the subpoena. And pursuant to those court rules, deposition is not public, and so we will not be recording the deposition. If you have a problem with that, you're going to have to take it up with the judge and seek some sort of legal recourse that way. But at this time, we're going to proceed under the normal rules, which state that depositions are private and not public.
But isn't this a fundamental question that may not be resolved right now? Why not he takes his recording and then we leave it up to the court to order what we've done without recording? Because if you stop him from recording at this moment and let us subject this or submit this for judicial clarification, that would have been too late because he wouldn't be called back to come out of record the deposition that has been completed.
I understand your position, and I'm just simply going to reiterate that under the rules of the court that issued the subpoena, depositions are private and not public, and we will not be using it in any way that violates the rules of the court. If you're going to seek legal redress from the judge in this matter to get some other type of decision, that's perfectly fine, and that's up to you. But at this point, the deposition was requested by the defendant. This is my deposition, not yours. And if under the rules of your deposition you're fine with getting your witnesses recorded, that's up to you. But at this point, again, I'm going to reiterate that I'm going to request the witness to turn off the recording, which at this point is still going on, even though I've already instructed him to turn it off.
Well, Counsel, at least let's finish this matter before we come to him turning it off. Let me clarify a point. This deposition is occurring pursuant to the order of Honorable Magistrate Day on March 9th. The deposition is pursuant to the order of the Court of Maryland, Federal U.S. District Court of Maryland. It is important we clarify the mandate under which this deposition is occurring. It is occurring pursuant to the decision of Maryland Court. Is that agreeable?
I will agree that this deposition is taking place pursuant to a subpoena for Mr. UMUNNA under the United States District Court for the Southern District of New York. And in that subpoena, there's no reference to any sort of video recording of the witness. I'm going to reiterate again that the rules for deposition state that they are not public but private, and we object strenuously to the recording of the deposition. I'm going to again ask the witness to seize his recording.
Counsel, one point that I want you to clarify is, what is the relevance of the order of Magistrate Day on March 9th regarding this particular deposition?
Could you repeat your question? I didn't quite get it.
On March 9th, Judge Day of the U.S. District Court in Maryland issued an order regarding this deposition. He determined where the venue should be. He also determined what date and time frame. So, what rule is applicable? Are you completely discountenancing the position of the Court of Maryland?
The court has requested that we take the deposition of the plaintiff today. The deposition, not the plaintiff, but of the witness, Mr. UMUNNA. His deposition will go forward today because we have requested it. And as I've stated before, and I'm going to state one more time, this is our deposition. It was made at our request, and it will be done pursuant to the rules of the court, which state that depositions are private and not public. You've made your position quite clear, and if you object to my position, then you are free to take that up with the court at some later time. But we will not be proceeding with a deposition on videotape.
Okay, I hear you, but you haven't answered my question. What rule governs? Is it not that of the court that ordered this deposition? Because apparently, in fairness to you, you are suggesting that there are two rules here. The rules of New York for the subpoena, or the rules of the court that ordered the deposition. Mr. UMUNNA was bound to appear for this deposition by the order of Maryland Court. The subpoena was absolutely unnecessary. The New York subpoena is not what is driving this deposition, but rather it is the order of the court in Maryland. So we should be talking about the rule in Maryland. And then I have to clarify that I'm not sure what the rule in Maryland is. If you point to Maryland rule, I will have no further objection.
Mr. Gonwe, I'm simply reiterating that the court has ordered this deposition to go forward. The subpoena was issued by the United States District Court for the Southern District of Maryland. I'm going to state again that the deposition is private and not public and will not be recorded. If you have an objection to that, I recommend that you take that up with the court.
Well, it is not so much my objection as the request of this witness. He knows what he wants. The issue you did is to, in fact, you will be directing any objections you have ultimately to this witness. You asked me a legal question, which is the legality or the propriety of him recording dates. And you pointed at New York civil rule. That's the point at which I came in to raise a question. And that question is this: is it New York civil rule that governs, or the rules of the court that ordered the deposition, which is Maryland court? I don't know the position of the rules of Maryland regarding video recording of these proceedings. You need to point to Maryland rule. If you put it on record, the Maryland rule does not allow this, and you're objecting on the strength of Maryland rules, I will probably not have anything else to say on this point.
And I'm simply going to reiterate that if you have an objection, you will have to take it up with the court. Under the subpoena, which was issued for this witness's deposition, it stated that the deposition will be recorded by transcription and by court recorder, There's nothing in the subpoena having to do with any sort of video recording equipment, and because this deposition will be private and not public, I'm going to instruct the witness to turn off the recording so that we may begin the deposition. At this point, the time is now 4:39 p.m. The deposition was scheduled to begin at 4 p.m., and we have now wasted an entire 40 minutes having a discussion about this, and I've already made the position of the defense clear. We need to begin the deposition.
Now, I've noted your point, but the issue is when you tell me to take it up with the court, which court will I take it up with? Is it the Maryland Federal Court or the New York Federal Court? Which one? I'm hoping you will give some guidance on this question and not for us to brush it aside as if it's irrelevant.
I'm appearing here as counsel for the defendant. I'm not here in any position to give you advice as to what legal remedies you need to seek from the court. You need to do that on your own. I do not serve as your attorney, and so I can't give you any guidance on that. I'm going to instruct the witness again to turn off the video recording equipment so that we may begin the deposition.
I have not requested you to serve as my counsel at all. I'm following up on the statement you made. You were the one that urged me to take it up with the court, and I asked you which court.
It is
I
not.
expect you to have an answer to that question.
It is not my responsibility. It is not my responsibility to give you guidance as to which court you need to go to seek legal recourse. I'm here to conduct a deposition ordered by the Southern District of New York. And I'm instructing the witness again.
Sorry, go ahead.
I'm instructing the witness again that he needs to stop the recording of this proceeding, which is private, pursuant to the rules of the Southern District Court of New York, which issued the subpoena. Please turn off the recording, sir.
And please, before you have your will automatically at this point, I'm hoping we can find a common ground without you really bulldozing your way. For clarity, I have not asked you to provide me legal advice. I don't think I should. I don't think there is need for that. The question is, you said we should take it up with the court. I'm asking you now, do you know which court you were referring to? Or are you willing to withdraw that statement that we should take it up with the court?
I have not advised you to take this up with the court. I simply mentioned that if you have an objection to it, the court is a relevant place to go to seek some sort of resolution. The deposition will proceed under the rules. It will not be recorded by the witness. I'm going to instruct the witness again to cease recording this proceeding.
But, okay, is it correct to say that your client, Mr. Sowore, have fears about the testimony being made public?
I am not making a statement on behalf of the defendant. I'm telling you that under the rules of the court, the deposition is not public and will not be publicized.
But you know that you do have, regardless of the rules, you have rights to waive any objections on this matter. Are you saying, therefore, that Mr. Sowore has reasons not to allow his testimony to be tape-recorded because it might become public?
I am stating again, sir, that a subpoena was issued for the deposition of this witness, which states that it will be recorded by transcription by a court reporter, not by anyone else. Under the rules of the court, the deposition is not public and it will not be publicized. I'm instructing the witness again to cease recording this proceeding. Well, you know, I cannot advise the witness. I'm not his lawyer at all. You actually called this witness. He is your witness. But the point I was trying to clarify is whether you are willing to admit on record, as you have impliedly admitted, that Mr. Sowore has reasons not to want his testimony to become public. Sir, I am not making any admission impliedly or expressly. I am simply stating the rules of the court, which state that a deposition is private and not public. I am going to keep repeating that the rules of the court state that depositions are private and not public. And explicitly under the subpoena issued for the deposition of this witness is stated that the deposition would go forward by court reporter and transcription method, not by any other methods.
as I stated once more, I wish I were in a position to give any advice to this witness, but I am not.
You're clearly not in any position to give advice to the witness, sir.
Yeah, so I am in as much the same position as you are relative to directing this witness. In fact, you probably would have greater leverage with this witness because he is your witness. You call him and you arrange for him to come to give you testimony. You're supposed to have adequate communications with him in terms of what he should come with or what he should not come with. I have done nothing to prepare this witness. Who is your witness?
Thank you
I
for...
would wish that this deposition would go forward. I wouldn't want this particular issue to interfere with the deposition, and I can basically urge, express my desire or wish that this witness would do whatever is necessary to ensure that this deposition goes forward, even if it will be without him being able to record it. Otherwise, I am in as much difficulty as anybody could possibly be. If the witness agrees, I'll be happy, and we will have a deposition as scheduled. But if he doesn't, I will have absolutely no control over him. It will be unfortunate that we have gotten to this point, and this matter became an obstacle.
Can I say something? Are you actually saying that, are you trying to deny me the opportunity to record my own deposition, which is not going to be made public, which at some point, maybe down the line, which of course these are court documents, will also be made public, maybe in a week, in 2 weeks, in a year or 2 years. I also have the opportunity to record my whatever I say in my own document, which is not a crime. So why are you trying to deny me the opportunity to record my own information?
I'm
or my
making
own
a
deposition?
statement for the record on behalf of the defense that depositions are private and not public.
Yeah, I mean, this is
Under the
private.
subpoena,
This is
under
also, yeah.
the subpoena, sir, you are here to give testimony in this case by transcription. If you have need of the record at some later point, the transcript will be available for you, but it cannot be recorded.
Counsel, can we have a compromise position, which is that we will get the witness to confirm that he will not make his record in public, that it is going to be for his own private
It's my own private
enjoyment.
document.
We still object.
Even if it's my own private document, without being on the website or anything.
We object.
Even though it's not going to be made public without your approval, you still
Yes.
object?
I'm going to state again that this deposition was requested by the defense. This is our witness. The deposition will proceed under the rules of the court that issued the subpoena. It is not a public forum, it is a private one. And if you need to take that up with the court at some later point, then that's what you can do. But at this point, I'm going to ask the witness again to turn off the recording so that we may begin the deposition. I really feel at this point that you are clearly obstructing the deposition from beginning. We have not yet started, and we've spent almost an hour going back and forth on this position. I've made our position quite clear that if there are objections to what we are saying, then you can take that up with the court.
Who's obstructing it, myself?
Excuse me?
Who's obstructing it? Who's obstructing it?
As I said earlier, I have no desire one or the other. I have no prior knowledge of this witness's interest in recording this. And when it comes to taking it up with court, who will take it up with court? I have no interest in taking it up with court. I am satisfied either way. And I will wish, I hope the witness takes it. I wish that the witness could, reconsider his interest in keeping a record for himself of these proceedings, and we go forward. But other than that general wish, I have no leverage or influence to control or direct this witness who is not my witness.
I would have loved to actually record this, but if you're asking me not to record it, I kind of feel like it's unfortunate, but I can go ahead and turn it off. So we can proceed.
Please turn it off.